As Bruce said, my name is Quinten. I'm with Vial, Fotheringham, or VF Law. And I just have to say, I'm really excited to be here. This is one of the first in-person classes that I've taught about 3 years now, since before COVID. We've been doing a lot of virtual stuff with our firm. I don't know if any of you have attended or participated, but I was excited to get the opportunity to actually come and speak in person, and welcome to all those who are online. So I was asked today to present on the top 10 ways in which boards and associations, I'm going to throw that in there as well, get sued. This is not an exhaustive list by any means. I tried to make the categories general enough to where it might encompass a few different things. But I take this from two different things. I take this from my own experience of doing this for 15 years now of HOA law and all the cases I've seen and experiences I've had. I'm going to share some more stories with you of some of the cases I've had. I recognize some of you in here. I'm pretty sure it doesn't involve any of you that were in here. So if it does, please let me know. The other source that I'm taking this from is the Department of Real Estate. Have any of you been involved with the Department of Real Estate? Any claims? Okay. Actually, let me back up. By show of hands, how many in here right now are currently on the board, serving on the board of directors? How many of you are currently serving as members of the board where you live? But in the past, have you served as board members? I see a couple here. Okay. Aspiring to be board members? Okay. Been there, done that, right? Okay, so the Department of Real Estate in Arizona has a process where homeowners and associations can try to settle a dispute. There's a bad echo. Can try to settle a dispute instead of going to court. It's a much quicker process. It's an administrative process, and they release statistics every quarter on the number of cases that have been filed, resolved, and the topics that are at issue. And so I took kind of my top 4 that we'll get to straight from that list. So we'll talk about that in a little bit. So the way I like to do this, I like participation. I don't want to be the only one talking, hopefully, for the next however long we do this. So please feel free to interrupt me. Just raise your hand and I'll try to call on you. Hopefully it's relevant to what we're talking about. If not, we can talk about it, but I may try to steer us back to where we are. But I like the participation. And just as let me see here. And just full disclosure, I didn't see the final version of this. My marketing director was doing it, so she may have snuck a few things in here. So just by part of an introduction here, I don't want all those of you who are on the board right now, I don't want you to go home after this and tender your resignation. Okay. As board members, you have a lot of protection from liability. Now, unless you're going off the deep end and doing something that's intentionally harming the association, you're going to be protected either from your own documents. I might put the indemnification word up there. If you look at your articles of incorporation, your bylaws, there's a good chance you're going to have language in there that talks about how you are indemnified from liability. And then there's also the statute. The Nonprofit Act has indemnification language as well. So even if you are sued, and that does happen, board members get sued all the time, you're going to be protected from any liability, and no one's going to, even if you were to lose, no one's coming for your house the next day. There's also the D&O policies, directors and officers insurance policies. For those of you who are on the board, if you don't know if you have this policy, that should be the number one thing you do after you get home today. Make sure that you have this policy as one of the many that you have for your association. My wife served on our board. I live in a small association. She served on the board and was on the board for probably 5 years. And I try to keep out of it. I would just kind of bury my head in the sand because they were doing some things and I just didn't want any part of it. But I found out about 5 years into it that they didn't have directors and officers liability insurance. And I couldn't sleep that night. At the first thing in the morning, we're calling the insurance company, we're getting this policy. So just make sure you have that if you are on the board, because that comes in very handy to protect you in the event you were to get sued. All right, any questions on that? Any introductory questions? Can everyone hear me okay? Okay. All right, so, and the first probably 6 of these are really not in any particular order. I tried to make it kind of the least frequent to the most frequent types of claims that I see, but some of them is just kind of a toss-up. So we'll go through these. Okay, CC&R amendments. This is actually has become a more common issue in the last couple of years. This usually what happens, association will try to amend their CC&Rs, homeowner challenges it and says that they didn't follow the proper procedure or whatever the issue might be. So every one of your CC&R documents should have amendment language. I've seen a couple that don't, but most of it's towards the end of your document. It's going to talk about the percentage of owners that have to vote to amend your document. And as long as you are, actually, I should say prior to March of this year, as long as you were following that procedure and you had the requisite number of owners voting, there wasn't a whole lot that owners could do to challenge that. Right? They could kick and scream and say they didn't like the change, but if they're in the minority group, then they're just going to have to live with that. The statute I put up there, the 33-12-27. How many in here live in a condominium? Okay, about almost all of you. Okay, that's good. This statute here is from the Condominium Act. I have some books here for those of you who are interested in taking a statute book with you. My marketing director just showed up. She's got some books there if you want one. 33-12-27 is the amendment language in the Condominium Act. It dictates how a condominium can amend your CC&Rs. And there's really important language in there. There's, just for those of you who live in condominiums, one of the provisions says that if you amend your CC&Rs in a way that changes the way in which a unit can be used, it requires 100% approval of your owners. So for example, short-term rentals. Okay, that's the big hot button issue. It has been for years. That is, I think, the perfect example of how that you're changing the way in which a unit can be used, right? You're telling someone you can't rent your unit for less than 30 days. If you were to try to amend your CC&Rs to include rental restrictions, you will have to get 100% approval from your homeowners for that amendment to be valid. At least that's the position I take. There may be some attorneys that disagree, but I think it's pretty well agreed upon now that that's going to require 100%. So that statute still in place, still governs. That dictates how. Now, if you live in a planned community, for those of you who didn't raise your hand before, the single family homes, there actually isn't as a robust of a statute. There is a statute, it's ARS 33-18-17, but it just talks more briefly about the process that you follow and how you can use, remember, her written consent forms. Most of the time when you do an election, you have a ballot, just like your annual meetings. A consent form would go out to all your owners and give them the chance to vote yes or no, but it's not tied to a meeting. So you can send out a consent form. It could take you 3 or 4 months to gather all those consents. And once you get the number that you need, then it's valid on that day. So that the statute talks about that. Hand in the back. Yep.
I have a question about the definition between a condominium and another type of residence,
Okay.
like say for a patio home. What constitutes a condominium versus a patio home?
Very, very good question. I think the simplest way I can answer that is when you look at your common property, you know, the pool, the park, who owns that property? Is it owned by the association as a legal entity, or do the owners share an ownership interest in that property? There's a couple ways you can find that out. You can go to the Maricopa County Assessor's page, find your community, and start clicking on those common properties and see what comes up. If it comes up that it's owned by the association, that's kind of your first sign that you're a planned community, that you're a single family home planned community. If when you click on it, nothing comes up, okay, then you may have to look somewhere else. That starts to indicate maybe it's a condominium. You want to look at your deed. Your deed will probably say, you know, unit 123 and a 1/100th in ownership interest in the common elements. Okay, that's a way you can find out that you're a condominium. So really, it comes down to property ownership. Now, that's not always the case. Sometimes developers screw it up and they don't deed the property over to the association like they should, or they keep it in the name of the association when it's really a condominium. So then you have to look at your documents and kind of sort through all that. But most of the time, the easiest way is just find out who owns your common property. And that'll tell you. And that's a really important question because statutes are very different. And so you really need to know whether you're a condo or a planned community to know which statutes you have to abide by. So that's a good question. Now, the Callaway decision, have you heard of this decision? The Supreme Court decision on CC&R amendments? Yeah, it happened in March of this year. Okay, well, I'm going to give, I don't want to take up a ton of time on this decision, but I will tell you what happened. First of all, for those of you who have been in associations or been involved in this type of work long enough, you know that the Supreme Court of Arizona doesn't get involved very often with HOAs and condominiums. It's usually just not important enough to the Supreme Court. It usually goes to the Court of Appeals, and that's where the issue dies. There was a small community in Tucson, the Tucson area, a five lot community. Actually, I think it was 6 lots, but it's 5 owners that own the property. And 4 of the owners were concerned about what the other owner was going to do to his land. He had all these big plans of building some, big house that was going to be bigger than the rest of them, and had all these ideas. And so they wanted to go in, the 4 of them, and amend their CC&Rs to prevent him from doing all of these things he wanted to do. The document required, I think, 2/3 vote. So the 4 of them had the votes to do that. They went in and amended the document. 4 of them voted in favor of it. There was the one opposed, but it didn't matter, and they recorded the amendment. The one guy that was singled out took a issue with it and filed a lawsuit. And he sued the association, saying that you didn't have the right to amend the way you did. You needed my approval, all kinds of arguments. Went to the trial court. He lost at the trial court. He lost at the Court of Appeals. They appealed it to the Supreme Court. The Supreme Court thought, this issue affects 9,000 or 9,500 communities in Arizona potentially. We're going to take a look at this. And they go in and do a analysis on this amendment process. And they've completely revamped the way that we can do amendments in Arizona. They've created this test now where amendments to your CC&Rs, they look at whether or not they were reasonable and foreseeable. Meaning if you bought your property in 1985, let's say you've lived there since 1985, your CC&Rs said whatever they said in 1985. That's what you agreed to when you bought your property. Fast forward to 2020, now we want to do an amendment for rentals, or we want to do an amendment for drones, or something that wasn't an issue back in 1985. Well, back in 1985, it wasn't foreseeable that this document was going to change to now prohibit rentals, or whatever the restriction might be. And the court took a real issue with that and said that's just not right. I mean, for lack of a more boring explanation, I guess. But they said that's an issue. And so if you're going to change your CC&Rs and it's going to be something that wasn't foreseeable or reasonable, you have to get the approval of all those owners that were owners at the time. And essentially what it's done now is created this situation where if you go to amend your CC&Rs and add any new restrictions, anything that wasn't there before, you're going to have 100% approval of your owners. Doesn't matter that your documents say 75%, 66%. Now, you can still use that percentage if you want to clarify something that's in your documents, modify something, but not adding new restrictions. And that's the key. And so what the Supreme Court did is they went through this document and they called it blue penciling or blue lining. Blue pencil. And there were 9, I think, different provisions that were at issue. And they went through each one and there's an explanation as to why this one's good and why this one isn't. So it's Callaway versus Calabria Ranch is the full name of the case. I don't have the citation with me, but if you just search Callaway versus Calabria, it's Calabria, Calabria Ranch. I'm sure you'll be able to find a website if you're interested in reading the case. The one problem this created for us, well, besides making it almost impossible now to amend your documents, is that there was nothing talking about being unable to go back in time and challenge previous amendments. So if you amended your CC&Rs 4 years ago, there's an argument with this case that an owner could look at that and go back 4 years and say, wait, you didn't have my approval to do that 4 years ago. Now with this case, that's no longer a valid amendment. So I haven't seen, this is brand new, so we haven't seen any of this litigated yet. But it is something that's on our radar. We're concerned about it as an association group, because there's a lot of communities out there that desperately need to amend their CC&Rs. If you're from the 60s, 70s, even the 80s, your documents are terrible in most cases for what you need today, whether it's raising your assessments or just being able to operate. And this has made it very difficult now for associations to ever change. They're kind of stuck with what they have. So I think this will result in more litigation regarding CC&R amendments as associations try to kind of maneuver through this case and decide whether or not this amendment is going to trigger this case or not. I've had to give advice on that many times in the last 6 months as whether or not I think this will trigger the case law. So yes, there's a couple of microphone.
So our association probably came from the 60s and it's been amended several times. Do those amendments from 4 years ago, as your example, still apply, or are they null and void now?
They still apply until a court says they don't,
Or
right.
until someone goes to court?
or someone has to challenge it. So all the documents that are recorded are still good until someone challenges it and the court says they aren't good. Yeah. So I just have to throw that out there with this case, because I think, like I said, I think we are going to see people starting to question. Now it's going to require, it takes a lot of money to challenge this kind of stuff. And so someone's going to have to be willing to fork over the money and question it. So it may not happen as much as we think it might, but I think it will happen.
Is there any sort of test for how far back you can go or not?
No, the court didn't really say anything about that. So one argument could be that you have a 6-year statute of limitations on contract issues. So if you're disputing a contract, you have 6 years to bring that claim from the date that the contract was breached. So I think there is an argument that any amendments older than 6 years old are you can't challenge those. Those are good. But there is this reference in the case to a document that was recorded without the proper permission is deemed void on its face. It's called void ab initio. And that there's an argument that would exceed that kind of renders null and void any statute of limitations. So there's kind of these competing arguments that could be tossed out on that challenge. So it remains to be seen what the courts will allow and won't allow on a challenge. So any other questions on that? Yes, sir.
So our CCNRs say 67%. Now that's no longer in effect. It has to be 100%, what you're saying?
It just depends on what you're doing to change your document. So if you're going in and revising your documents to just clarify some vague terms, okay, you can still rely on the 67%. But if you're going in to add a new restriction altogether, like maybe a new parking restriction, new rental, something that wasn't there before, you're probably going to trigger that case, and now it's 100%.
Okay, thank you.
Yep. Parking violations. This is another one that I see every once in a while. Usually what happens is the association will try to enforce whatever parking restriction they have, and either they pick the wrong car, right? The car is not related to the owner that they go after, or they cause damage to the car, or maybe they just didn't have the right altogether in their documents to do what they did. And the owner will challenge, maybe sue over the parking, or they might put in a parking policy that owners don't agree with. So what I want to say about parking, the ability to restrict parking really depends on what's in your governing documents. And when I say governing documents, I mean your CCNRs. Now, you may have stuff in your plat, on your plat map, if you can still read it. Now, your community, you may not be able to read your plat from 50 years ago, just the way it was created. But most parking restrictions are going to be in your CCNRs. That's where they should be. So you need to look there first, and you need to determine what is it that we can enforce. You know, can we tow their vehicle? If your CCNRs are silent on towing, I am really leery about associations towing vehicles if you don't have it in your CCNRs. You also need to look at your streets. Do you own your streets as a common area, like we talked about ownership of the property? Is it a private street or is it a city street? That makes a big difference. If you own the street as a common property, as a common area, you actually have a lot more latitude in creating rules and trying to enforce what happens on your street. But if it's a public street, you can still enforce parking restrictions, but you're going to be limited in what you can do. Towing companies get a little squirrely about towing cars off public streets. There's a signage requirement. You have to post signs in certain areas, which can be difficult on public streets because where are you going to put the sign? You know, in someone's yard, it can become difficult. But so some communities, because when they have public streets, they'll come to me and think that they can't enforce parking restrictions. That's not the case. You know, your documents are still, people are still bound by their documents. You may just be limited in the remedy that you have in enforcing parking. You may only be able to implement fines, or maybe you can suspend their rights to use something because they're in violation. But what I wanted to mention there, the two things there, the parking policy. How many of you have parking policies in your community that you know of? Okay, a couple of your hands. Okay, if you don't have a parking policy and parking is an issue, if parking is something that you're concerned about in your community, I would strongly recommend that you have a parking policy that lays it out real clearly what the restrictions are and what the association can do in the event that you don't comply. There's two reasons to do that. One is it takes it out of the CC&Rs, which is a little bit easier to follow. People don't have to flip through a 70-page document. And it clarifies things for people. It can be written in a way that's a little easier to understand sometimes. Now, with any policy that you create, remember, it's just like any rule. You cannot contradict what's in your CC&Rs. Okay, so if your CC&Rs govern parking and talk about the different elements of parking, you can't make it something different than what's in your CC&Rs. It'll be a void policy if you do that. Now, if your CC&Rs are silent on an issue and you create it and you have the proper authority to do it, then you could possibly create a rule that addresses that issue if the CC&Rs are silent. But just be very careful if you are going to make a policy to not contradict your CC&Rs, because that could lead to liability as well. And liability meaning someone could challenge it and kind of overturn your policy. Yes, ma'am. Hold on, there's a microphone.
Okay, so we have a gated community where I live, and there's reserved spots. If you have two cars, you have one reserved spot, there's a number. And then we also have what you would call special parking spots for wheelchair. So is it assumed then that we would have a policy, or that shouldn't be assumed? Or
Yeah, you should never assume you have a policy. I'm sure you have some pretty good language in your CC&Rs that addresses all this.
okay.
But it might be worth looking at whether you need a policy or not. But yeah, I wouldn't assume you have one.
Okay, thank you.
Yes, ma'am. Just right behind you, Bruce.
I'm just going to go for definition of a word. When you say policy, that's not the same as amendment. So if it's not in the CC&Rs that we have a restriction for towing or specifications, then the board could create a policy concerning towing and parking. Policy is not an amendment.
Yeah, policy is not an amendment. And let me back up a little bit on that. So when I say policy, that's essentially a rule. Okay, every board, you need to look in your documents, but you should have rule-making authority as an association. And that's the ability to create rules, change rules. And that's something that the board does on its own. You know, at a board meeting, obviously you would do it, but you have that policy, that ability to create those rules. Policy is just kind of another word for rule. So you would create a set of rules that govern parking that don't contradict your CC&Rs. Now, whether you add towing to a rule if your CC&Rs are silent, that's something you want to talk to your association's council to make sure that's okay. I would advise against that if you have public streets. But if you have private streets, those are common elements that the common area the association owns. You have the right to govern as an association what happens on your property. That's where I think you have a lot more latitude maybe to create a towing policy or towing in your rules. So it's just got to work through some of those things. But yeah, it's just a rule. Yeah. Yes, sir.
Almost there.
No, in our development, you get a condo, you get a parking spot. Now, with COVID, Canadians couldn't come down and re-register their car. If you're in your own parking spot, does the association have the right to tow the car since it's unregistered anymore?
That's a good question. That's going to depend on what your documents say, is whether or not, what is being unregistered. First of all, we have to determine that's a violation, that you're unregistered. I will use the phrase that a lot of attorneys like to use, and that was, it depends. It's hard to answer that without seeing what your documents say. Maybe they could, but you'd have to look closer at your documents on that one. Yeah. Now, the one thing I would say too is, as a parking space, if it's assigned to your unit, it's likely considered a limited common element that's attached to your unit. The parking restrictions may may not jump onto limited common elements. It may just be for the common elements, which would be parking anywhere else. That may be something that we'd want to look at to see if it goes as far as to say, if you park on your limited common elements, we can still come after you if you're in violation for some reason. Yeah, so we'd have to look at the CCNRs and see. Yeah, so the question was, that'd be like a patio, which is a limited common element. You're right, it is like a patio, a storage shed, something that's attached to your unit, not a unit, but it's assigned to you as your exclusive use. But a lot of times associations do have the right to create rules that govern limited common elements. Like they can tell you what you can and can't put in your patio. Like you can't store boxes on your patio. So same sort of thing where the rules may be able to go on to the limited common elements. Yeah, good question. All right, any other questions about parking? All right. Okay, personal injury. Any of you had a claim that you know of in your community where someone's gotten hurt? What do you mind sharing what it was? If it was you, you don't have to share it, your own story.
It's fine. It's already been settled. Our development is, I think, 26 acres. We have retention pond basins to collect the water. A tenant, decided she would chase her dog down there one day. And let's just say maybe she wasn't entirely lucid.
Which is very common.
And she fell and she injured herself and she sued us because there was a hole in this, or an area that wasn't walkable. And yes, she won well into 5 figures.
Yeah. So very, very common story. I have 2 cases right now I'm defending involved the same issue. Someone was walking on the community sidewalk, claims they tripped on an uneven set of the sidewalk. One lady fell directly onto her face. And I mean, the picture, you can't dispute the pictures. I mean, she took it pretty bad. The other guy fell and claims to have hurt his back. We're still trying to sort that one out. But they've got claims now. They filed against the association. There's a community I used to represent right by here. Same sort of story. Guy was walking through the common area yard and his foot went in a little depression. And I never saw it because the maintenance guys filled it in pretty quickly. But he tripped and fell and hurt himself. So these things happen. There's attorneys that are just itching to get a case like that and, make a whole bunch of money. The takeaway here are a couple of things. One, make sure you have proper insurance for your community. This would be a general liability policy. Whoops. This would be a general liability policy. Yeah, what did I do here? Hold on, I'll get it. And if for those of you in your condominiums, you want to look at the statute, there's just make sure it's the right number here. I think it's ARS 33-1253. Just make sure that's the right number. Nope, 1253. ARS 33-1253 for those of you in condominiums. There's a whole section in the statute on insurance. It talks about what type of policy you should have. But you want to talk to your adjuster, make sure you have enough coverage. The policy you had 10 years ago may not be enough today, as the numbers go up. So make sure that you're properly covered. And also it's good to, this usually highlights, a lot of these cases will usually highlight the association's failure to properly maintain or properly monitor their property. How often are they inspecting the roofs? How often are they inspecting the sidewalks to look for those deviations? And if you can show that more consistent pattern of reviewing it, that's going to help. If you sit back and don't do anything, that can be used against you in a case. So, you want to look to those things if you're on the board. Make sure that you're aware of what's going on in your property and have someone, your maintenance crew, take a look at it. Question here? So the question was, can I repeat the ARS number? It's and I guess I didn't have it up there. Oh, is being dictated? Okay, I'll try to talk slower. ARS 33-1253, 1253. Yep. Real quickly on the insurance thing too, be careful that a lot of times your CCNRs will dictate the type of policy you need to have. You know, and this is mainly for condominiums, you know, are you required to insure the units? Or are you only required to insure the common elements, the buildings, you know, the exteriors? Condominium close by here about 10 years or 15 years ago now, we were representing them. It came time for renewal on their policy, and
the engineering department is chosen right now to fix our lights outside.
that's all right. So they came time to renew their policy. They had the adjuster come out. Adjuster didn't look at the CCNRs very closely. They changed the policy from basically an all-inclusive, we're going to insure everything, to just the buildings. And they took the units out of it, you know, to save some money. And as luck would have it, within that 1 year of the policy, one of the units caught fire and burned down. The owners weren't properly notified that they no longer had insurance for their units because they were just relying on the years of history of insurance. So the lady had no coverage for her unit. She sued everyone. I mean, manager, insurance company, association, and as you would expect, she won, and she got the money that she deserved. But the moral of that story was, be very careful when it comes time to renew your policy. Make sure that you are insuring the parcel and the areas that you need to insure. On the reverse side, I've seen communities get these big policies for areas that they have no duty to insure. You know, you may not have to insure the units, but and that's a big difference in your premium, if you know, depending on what you have to insure. So you want to make sure, and if you need the attorney to look, have your attorney look, but make sure that you have the proper insurance for your community, for financial purposes and liability purposes. All right, that's enough of personal injury. Okay, now this is kind of a broad topic here. This could cover a whole lot of things. I'm not very creative on the topic, so that's why I put the more specific issues here. And this is what I want to focus on, because a lot of what we talk about today could fall into that category of failing to follow your governing documents. Okay, that could encompass a whole bunch of stuff. But these three topics here are things that I've dealt with in the last however many years that I wanted to bring up. So assessment provisions. Your CCNR should have a whole section on assessments and how much or when you charge it, how much you can raise your assessments, budgeting requirements, which I've also have up there. You want to be very familiar with that if you're on the board. When it comes time to look at your budget for the next year and determine how much you can raise your assessments, you are going to be bound by either the statute or by your documents. But your documents can be more restricted than the statute, and the statute says that. Like if you're in a planned community, you can't go more than 20%. But if your documents say something less, 5%, you're bound by that. Condos don't have a cap in the statute on assessments. There is no cap. You could go up 100% if you wanted to, but your CCNRs are likely going to put a cap on that. And the one you hope for is that it's not tied to CPI. Although CPI right now is great. CPI I think is 8 or 9%. It's the consumer price index. I say that all joking aside. I mean, it's not great that it's that high, obviously. But for associations who want to raise assessments, and 5-6 years ago, you were at 0.5% to raise your assessments, or 0.7, something like that. So if you're tied to CPI and you want to raise your assessments, this is the time to do it. But was there a question in the back?
Yeah, are the statutes always superior to our CCNRs, or in a case that I'm considering, is it superior to our bylaws?
So the answer to your first question is no, they're not always superior. And let me give you an example. I don't know if I'll be able to find it right off the top here, but many times in the statutes, you will see one of two phrases. Well, I see a typo in that one right there. Hey Terry, 33-1809 has a typo on it. So one of the provisions that you're going to see, like for example, 33-1808. This is a statute that talks about flags in planned communities. This is notwithstanding any provision in the governing documents. Okay, so we don't care what your documents say. This law applies. So that in that instance, that would trump your bylaws. It would trump your CCNRs. Whatever it is. Now, the other phrase is, I think it says, unless otherwise stated. And I can't think of an example right now, but I know that's what it says, something to that effect, that unless stated otherwise in your CCNRs. A good example is the assessment language, where it will say you can cap it for 20% unless your documents have a lower percentage, then you have to go with that. A lower percentage. Yeah. So a lot of times your CCNRs will say, maybe it says 10% is the cap. Well, the statute says 20, but the statute also says if your documents say something lower, you're stuck at 10%. So it just depends. And to answer that question is again, it depends. You have to look at what the statute says and whether there's that qualifying, that conditional language about how the two work together. So when it comes time to assessments, just make sure that you clearly have read and understand the assessment provisions in your CCNRs, because that's going to dictate what you do. Some of your documents may require a reserve study. There may be certain requirements about budgeting of how often you have to, or how many months prior you have to submit your budget, whether or not it has to be ratified by the members. For a lot of condominiums, you have that ratification process. There's a statute that talks about that as well. So you just want to be aware of that. One case that I wanted to tell you about on that one is we have, this is a case I defended down in Queen Creek last year. There was a master association and then a sub association of about 72 owners. And probably 10 years ago, they were in a fight over the amount of assessments that the master, so the people in the sub association had to pay the master fee, and then they had to pay their own fee, or so they should have. And it was all messed up. They weren't following their documents on levying assessments. So the master association was charging a separate assessment to the sub association, and there was a fight over how much that should be. That's just, I guess, the simplest way to summarize it. Well, they entered into this agreement like 10 years prior. Fast forward 10 years, the new board said, you know, we don't like that agreement. We think we should change it. And as a board of the master, they just changed it and recorded this new document that dictated how these 72 owners were supposed to pay or what they were supposed to pay. That turned into a lawsuit. The sub association sued the master association, and we had to sort out this assessment language and an agreement from 10 years prior, and kind of understanding that we were able to settle it and resolve it. But it was just an example of how, and it was kind of that trickle down effect too of the board from 10 years prior really messed up. Like they really had no authority to enter into that agreement that they entered into. I mean, zero authority. And in fact, there were two different legal opinions that the board had received that 10 years prior. And the board at the time was like, we don't care what these attorneys say, we're going to do this. And they just pushed forward despite the legal opinions. So it was a bad case, but it's just an example of the assessment issue, how that can lead to litigation. We've had issues too on the budgeting. One of my partners in my firm, she represents a condo downtown Phoenix, and their what is the device called? It's basically like their central air unit, but it's not what it's called. But anyway, it's old and it's about to fail, and it's going to cost, I think, $2.1 million to repair this device for the whole building. And their documents have terrible language about special assessments and raising assessments. And so we're having to navigate through, can we just change the budget for next year? And we'll have to jack the assessments up a couple 100%, to start collecting the money. So those types of issues, and I'm sure there's going to be litigation at some point on this one because it's a mess.
It sounds like we should use counsel more often. Sounds like we should just, before we make decisions on a board, just say, is this the time that we,
Yeah.
and I guess I'm asking, does the property management company say, looks like you guys need help with this?
So there's two things to that I will say. One is I'm please don't think that I'm here to try to promote myself or promote more work. I'm not. But there is wisdom in what you say. There is and we're going to get to the fiduciary duty claim. I think that's coming up here soon. Board members have this fiduciary duty that we'll talk about. And when you rely on the advice of an expert, and whether that's an attorney or an accountant or maybe a property management company, board members can receive legal protection from that. It's called a safe harbor rule, where we relied on the advice of counsel. So if everything hits the fan, the board can say, hey, we were just doing what our attorney told us to do. And that's a legal defense that board members can use. So that's why we do push legal opinions on certain things. Not everything. You don't need a legal opinion for everything that you do. But if it's something that's a high dollar figure, big, could draw out for a couple of years, you should have legal counsel take a look at it. I mean, the $300-400 you might spend on an opinion is going to be much cheaper than having to fight something like this and pay your deductible. And so anyway, that's a good question though. Any other questions on this one? We're doing on time here, 1:46.
In our CCNRs, we're required to have a budget every December and we're supposed to pass it. We have not had a budget for many years now, right? These two ladies are in the same condo.
Okay.
Okay, what can we do about that? I mean,
So the statute says that if you fail to ratify new budget, it'll just default to the prior year's budget. So
okay.
I mean, some communities will just ride that old budget for years because they can't get a new one. Now, I'd be curious to see what your documents say about the process to implement a new budget. Because if your documents require you to ratify a budget, then that means the owners get a chance, a say in it.
I think it did.
Yeah, so it doesn't mean that you have to get a percentage of owners to approve your budget. What the statute says is that, I can't remember the number off the top of my head, but a certain percentage of owners can vote against the budget. And if you get to that number, then your budget's defeated. But if you don't get to that number, then your budget's approved.
Since we didn't see it, we couldn't do that.
Also, as owners, you didn't even see the budget.
No. No.
Well,
Our management company does not send us anything.
interesting. Okay,
Yes.
well, I mean, that obviously is an issue. And we're gonna get to wait till number 3 on the list, and we might be able to come back and talk about what you could do. Yeah, let's just hold that for that one. I think that we can come back to that. So, and like I said, there's all other ways, so many other ways that boards can fail to follow your governing documents. So I'll just say this, for those of you who are on the board, if I'm teaching a whole class of board members, I usually ask for a raise of hands of how many of you have read your documents. You know, have you actually read your CCNRs or read your bylaws? And I'm usually surprised at how many haven't. I mean, and I figure, you know, if you're going to serve on the board, you may not understand everything you're reading. And I can tell you there's a lot of things I don't understand that you just make your best educated guess at on how that would be interpreted. But you got to make an effort to read your documents and do your best to understand them and ask questions if you don't. So Bruce in the back.
Yep, we got an online question. So homeowners have been recently charged for stucco repairs on the perimeter walls that adjoins and faces common area. Plat states HOA maintains these walls. What can homeowners do? CCNRs also indicate association maintains common areas. Extremely costly due to association neglecting these walls for years. 4 years ago, association paid for these wall repairs and now different directors.
That's kind of a perfect example for one of the other ones on the list. So I'm going to just kind of punt that one down the list a little bit because I do want to address that. All right. Any other questions on this general one? Okay. Now we'll get into a little more exciting ones here. Fair housing. Who in here has been on the board or dealt with a fair housing claim in your community? Do you remember what it was about? Oh, we'll wait for the microphone.
Yes, an owner is a part-time owner, put in hardwood flooring for fair housing and he rents out his apartment unit to other people while he's not living there.
On the second floor?
On the second floor.
Yeah. That is so common. Yeah. I have litigated that issue too. And we were actually able to successfully defend against a claim where a lady insisted on putting hardwood floor in, and we were able to defend against her fair housing claim, but they're hard. That's a hard case.
As was where our president refused to give a lady who was in a wheelchair a parking space. And so it ended up with a $50,000 fine and a registration for us all to go and hear why it should be allowed.
Called sensitivity training.
Right.
That's right. So, okay, those are 2 really good examples. Let's just talk briefly about the fair housing laws. This could be a whole hour-long, maybe even longer class that we could talk about. But let me just give you the quick summary of it. So fair housing laws, it's both federal and state. In Arizona, they mirror each other for right now. And what it essentially means is that there are certain classes of individuals who are protected by this law. And that would be sex, nationality, race, disability, or what's referred to as familial status, you know, those with kids or just kind of that family structure. Those individuals, if you fall into that group, you have the protections of what this law says. HOAs are governed by the fair housing. They're bound by the fair housing law because they're considered housing providers. Even though we're not renting homes to people, we're still considered a housing provider as an association. So we are bound by the fair housing laws. Now, we could get into another discussion about whether we're bound by ADA, and I will say that in most cases you're not bound by ADA, but the fair housing is almost identical in its application to the ADA. You may not have some of the requirements like putting in certain pool equipment or having a wide enough parking space, but that could come with a certain request under fair housing. It just kind of depends. So what fair housing says is that, and the most common one that you get is the disability category. Okay, someone, whatever the disability might be, needs an assistance animal, assistive care animal, needs hardwood flooring because maybe they have bad allergies to carpet, and that's a disability. Or is in a wheelchair, just like your example. Okay, that's the most common one that you see. I have dealt with cases that deal with race. I had an individual who, African-American, who sued the association claiming fair housing violations. We were sending notices to him because he was Black. I had a national origin case one time where an employee of the association was an Italian-American, is what he said. And he was fired for cause. He punched another employee in the face. He was fired the next day, sued the association, screaming discrimination for national origin as an Italian-American. So those do happen, but the most common one you will see in associations is disability. That's the request you will see time in and time out if you are on the board. And what it means is that just because of their disability, they are not able to enjoy the use of their property because of a certain restriction that's in place. Hardwood flooring, you can't have hardwood flooring in the second floor. Well, I can't use my unit being allergic to carpet if I can't put hardwood flooring in, so there's that connection. So when you have a case like this, there's a couple issues that you have to look at. One is, are they disabled? Okay. The definition of a disability is about as broad as it gets. It's essentially any condition that affects one or more major life activities. Each one of us in the room here, we might have something going on where it might be considered a disability. I mean, it's not something you have to see necessarily. Those who have assistive care animals, a lot of time it's a mental thing. It's not a physical manifestation of a disability. So you have to be very careful on that. So the disability question comes into play. Are they disabled? If they are disabled, they now have to show a connection between what they're requesting and their disability. So I'm blind, I need a seeing eye dog. That's easy, right? Hardwood flooring and allergy, there you can establish that connection. But if they need an animal because of allergies, okay, that may not work, right? There's not really it's called a nexus, but a connection between those two issues. If there's not that connection, as a board, you can deny that request. You can say, sorry, your fair housing doesn't apply. So it's that analysis that has to happen every time you get this request. They also have to make a request, right? If you see someone that's disabled, as a board, you have no obligation to do anything. You don't have to go up to that person and say, hey, what can we do for you? Can we offer you an accommodation? They have to come to the association first and make a request. And then you go through that analysis of whether or not you have to give it or not. So I have two stories that I wanted to share here. In fact, before I share those, let me talk about these last two bullet points. So reasonable accommodation and a reasonable modification. Have you heard of these phrases before? So a reasonable accommodation is someone coming to the board saying, I need an accommodation from an established rule or restriction, like no pets in the community. Well, I have a seeing eye dog, or I have an emotional support animal. Okay, I need an exception to that rule. I should be allowed to have my pet. It's not a pet. I should be allowed to have my animal on the property because of my disability. Okay, that's an accommodation to the rules. A modification is where they actually need to make a change, like physical change to something in the community to accommodate their disability. They may request to put in a ramp. Okay. Or they may want to make a change to the common element or common area park. They want to put something in. One thing to remember, I'll say real quickly about modifications, is that if an owner comes to the board and wants to modify something, they have to pay for it. Okay, the association doesn't pay for that change. Association will have to pay to maintain it once it's installed. And you can't force the owner to restore the property to what it was before. But to install it, to make that change, it is on the owner with the disability to make that change. And a lot of times when you tell that person that, the request magically disappears many times because they don't want to pay for it. So just know that if you are on the board, that is something. Now, one more thing I'll say is that anytime you get a request like this, it is really important to talk to counsel, because this is one of those things where if you end up at the Attorney General's office, like probably what happened to your group, you are presumed guilty until you can show your innocence. I mean, they will come at you with a heavy hand. And so you want to talk to your counsel and walk through, because it can be a minefield that you're walking through on these types of claims. Yes. Oh, wait, sorry.
Okay, we're having a request to have handicap ramps put in off of our parking area. However, in front of every disability parking spot, there is a access. I mean, you can wheel a wheelchair up. So we are not required then to do this for this person who's requesting it? Because we're
Probably.
looking at possible double-digit thousand to do it.
Now, I have to be careful what I say.
Yeah.
I'm not here to give legal advice, but my kind of educational purpose, I would say you probably don't have to honor that request. But we'd have to look at everything that's going on and make sure that you're checking all the boxes before you say that. But
So check with legal counsel.
You should check with legal counsel on that
Okay, thank
before you say yes or no. Because I mean, you remember, if you go and spend $100,000 when you really didn't have to, now all these other owners are like, why'd you spend all of our money on this? And so you're kind of in a rock and a hard place. So you need help through that. So talk to an attorney. Discriminatory behavior, and then I'll share with you my examples. This was a change about 5 or 6 years ago. The federal government came in and said, we're going to add a couple other requirements to the fair housing laws. And the discriminatory behavior is this: if the association is aware of activity in your community where someone is being discriminated against based on one of those protected classes, and the association does nothing about it, you are now liable under the fair housing laws as an association. Now, the law doesn't say you have to stop the behavior. You just have to address it. Okay, you can't ignore it. So I have an example of a community in Mesa. There's a lesbian couple that lives in the community. Now, the sexual orientation is not protected under the federal fair housing laws as it currently stands. And actually, it's not under Arizona yet either. They've been trying, but let's just assume it was, and we treated it like it would have been. Their neighbor across the street was a pretty disgusting individual, and he would go out of his way to make comments to them as he would drive by, and she had it on her Ring door camera, like she shared all these videos with us. And you know, when you see those videos, I don't know if it's going to help to close that door, but yeah, okay. When you see those videos, now the association's on notice that this is going on. Okay? And so my advice was, you got to do something. We sent a letter telling them to cut it out. Now the documents, I can almost guarantee you, your CCNRs are not going to specifically address this. I mean, it's just not something that's in documents. But you can send a letter to say, cut it out, you know, kind of a cease and desist letter. And once you do that, now the association can show, hey, we did something, we tried. And if it goes on, it may become an owner to owner dispute, but at least we're not going to be liable under the fair housing laws for doing nothing. So just be aware of that. If you become aware of discriminatory behavior, you're going to have to take some sort of action. And again, that's where your counsel can be very valuable in helping to determine what needs to be done. Now my examples here, I have two stories. What time is it? We got time. All right. So I have two fair housing examples I wanted to share. These are two cases that I have. One has pictures, the other one I didn't have time to put up pictures. So this is a community out in Avondale, I think. And the community manager was driving by one day and she saw this. She saw these posts going up, right? Bless you. All around the perimeter of the property. And then within, I think, 30 days, this was what it looked like, okay? This individual used to be a member of the board, was the board president for many years. Got off the board, and it was probably 5, 6 years later, decided, you know what, I'm just going to do this. I'm just going to throw this up, and they're not going to stop me. We sent a letter saying, please stop. You don't have the right to do this. You don't have approval. He didn't. He continued on. He changed, as you can see. He extended out the gate on the side there. He tore down the brick wall. And then on this side, he did the same, put in a new gate. and then had the fence. This is a sliding gate across the driveway that he put in as well. Excuse me. So he had his whole little compound there, right? Yeah, make sure you don't trespass. And I'll show you why in a minute. So we had to file a lawsuit to address this issue. And in defense of the lawsuit, he filed a counterclaim back against the association saying we violated the fair housing laws, saying that he was disabled, he suffered from PTSD. He's a Vietnam War vet, suffered from PTSD, and building this enclosure kind of created that safe space for him to avoid the commotion and because it would trigger his PTSD without it. During the litigation, he sent us this picture. His claim during the litigation was that before the fence was installed, he would do armed patrols of the community. Now, if you saw this guy, he's about this tall, he's probably in his 60s, physically had a hard time walking, just in normal clothes. And so I saw this, I thought, really, you're putting on a bulletproof vest, you're walking. Then he said he was in his Can-Am, he'd drive around, and the whole thought of it was kind of spooky, especially when we received this picture. So now, if you think back to what I was talking about, you have your disability. You have to establish that necessity, right? You need this accommodation for your disability. So the disability he claimed was PTSD. I wasn't going to question that. I mean, he served in Vietnam. My father-in-law served in Vietnam. I mean, I get it. We didn't go there. We just agreed, you know what, you're disabled. That's fine. The problem we had though, was the connection between the two. This guy had lived in this property for probably 12 years before he did this. Last I checked, the Vietnam War was in the 70s and 60s, right? And it's not like something just happened that triggered his PTSD. So where's the necessity? Where's that connection between the disability? And that's what we fought him on. We said, I thank you for your service kind of thing, but we don't see the connection that would require you to have this structure. He said his necessity was he no longer had to do these armed patrols. Now he could sit back comfortably in his house without having to do the patrols. Judge didn't buy that argument. We unfortunately had to go to a 2-day trial over this, but we won on it was because of that issue. He couldn't show the need for an accommodation. The problem with these types of cases, though, is you spend a lot of money. The association spent over $100,000 in attorney's fees for the 3 years we were litigating. The court struck those fees to 50, so they cut us in half on the fees. We actually were able to recover that 50 down the road, but anyway, that was one of the more extreme examples I've been involved with in fair housing. I had another case a couple years later. Lady wanted to the claim was that she wanted to put ramps into her unit, and her unit in the front had maybe a little lip that you see in the door jamb, right? There was no steps or anything. It was just right off the sidewalk into the unit. In the back were 2 steps down into an enclosed patio that went to the covered parking behind the unit. They're townhomes. And she claims, and her husband was a paraplegic, full wheelchair. They claimed 2 years prior to the lawsuit that they went to a board meeting and made a request for ramps. There is no evidence of this, nothing in the minutes. None of the board members remember this, but they're adamant. They were there, they made this request. And we didn't do anything because we never got a request. Well, so they were saying, well, you ignored us for 2 years. That's deemed a denial of our request. Therefore, you're liable under fair housing. And they got an attorney that likes to sue associations, and he sued us in federal court. And that was the fight over whether or not she'd made the request. And that was our whole argument. You never requested it. So how are we supposed to act when there's no request? But we didn't have records and the minutes were terrible. So it was a good lesson for the board at that time going forward to make sure that their minutes were better than what they were, because they were awful. But thankfully, this couple decided to move to North Carolina. We settled the case. So we never saw where the court would have sided on that, but it came down to whether or not she needed the ramp or he could just go in. And the ramp in the back was enclosed. They didn't even need permission to put that ramp in. It was nothing. It wasn't visible from neighboring property. They could just do it. But anyway, that was another example. So it does happen. And like I said, the most common one you will see will be assistive animals, and the need for those animals, despite what your CCNRs may say. So just be careful with fair housing claims, because they can get ugly. Yes, Bruce. Oh, in the back.
So we have two questions from our online audience. First, homeowner has a 2-story townhouse. Husband can no longer walk upstairs due to ALS. They want to now rent, but no more renters allowed since 2004. Can they use fair housing laws to see if they can rent their 2-story? Market not so good now and not good time to sell. Also, they may want to leave it to their children after death.
So the accommodation there would be, they want to be able to rent it so they can move out into a more user-friendly home.
Correct.
That's a good question. They may have something there where they may be able to make that claim that they can no longer use their property, and because you don't allow us to. But see, then there's that connection of the renting versus the disability, right? It has nothing to do with whether or not you can go up the stairs. Like, you just want to move, but you don't want to sell it. So that's a tough one. I don't know for sure of how that would play out.
Okay, we had one more. Does the fair housing protect residents being harassed due to religion?
Yes, I'm sorry. Religion's another one that was on that list. I forgot to mention religion. Yep, it would.
Just as a therapist, I would just ask if there's a bathroom downstairs and he can sleep downstairs.
That would be a kind of a counter argument to that for sure. Yeah. There's another question over here. Okay. All right, I want to make sure we get to the rest of these just in the interest of time, but if there's more stuff about fair housing, I'm always anxious to talk about it. But hey, Bruce, I think we have one more question here.
So if we have larger dogs and it's an assisted animal, should they have made a request to the board to have the dog?
If your rules say no, like have a weight limit on the dogs, yeah, they really need. And what I've done for some people is that we go back retroactively and just say, listen, we just need this on the books, essentially, like just for future boards, we just need this on the book. So just fill this out and make the request and we'll approve it. Just let's do the paperwork for that. So there's no question. All right, number 5 on the list are open meeting laws. This, whenever I'm teaching on the statutes, this is the one statute that I tell every member of the board, you should know this frontwards and backwards. Okay, this is the statute that's violated more than any other statute, in my opinion, in the books. Now, it doesn't mean necessarily it leads to litigation all the time, but I would say week in, week out, this statute is being violated by some board in Arizona pretty regularly. So, and maybe it's your board. So we know which one. And it's easy to do. It's easy to do. So those two statutes I have up there, 1804 and 1248, one's planned community, 1248 is the condominium statute. Read that and know what it says, because there are many things that it governs with your open meeting laws. It talks about regular meetings, the open meetings. It talks about your executive meetings. I think one of the more common violations I see it deals with board members who start discussing things in executive that they have no business talking about in executive. Here's an example. So if you're familiar with the list, there's 5 things on the list of things that you can talk about in executive, and only those 5, right? It's attorney-client privilege information is number 1. So you get an opinion from an attorney, you want to talk about it in the meeting, your attorney's there. Okay, go into executive. Please go into executive so you maintain that privilege. You start talking about that to the owners, you've waived that privilege now, and I can't get it back. Once it's waived, it's waived. So keep that in executive. Pending or contemplated litigation is the second one. So there's a lawsuit going on, or one's coming. Okay, go into executive. You can talk about that with your attorney. The third example deals with personal information about an employee of the association, or an employee of the association, or an employee of a vendor of the association, essentially a contractor. So if you have your manager or attorney or someone that you want to talk about, or if you have employees, any of you have employees that you know of? Most associations don't. They're just independent contractors. You do. Okay.
And so, I'm sorry, it's our maintenance man. We did the procurement, but then they hold presently the contract for him.
Okay. There's one other hand in the back here.
I would like to know if you can tell me if a property manager is an employee of the HOA board. And, okay, I was gonna say, and if that property manager also resides in the community, if that is considered a conflict of interest.
So I can't tell you for sure whether or not they're an employee. That depends on what the deal says, but I can tell you that 99% of the time, they're not employees of the association. They're independent contractors. They work for a management company that the association hired. Whether it's a conflict or not, probably not. But it just kind of depends on what's going on, what's being done, what kind of money's being exchanged. More than likely, it's not a conflict. Is it desirable or ideal? Probably not, but I don't think that it rises to a conflict. But so back to number 3 on that list, though. So you have personal information of that employee or personal information about the manager. What it doesn't include is discussing the actual vendor, the contractor. So you want to talk about your management company. You're not happy with your management company. Okay, that's not an executive session issue ever, and unless it's coupled with that attorney-client privilege. If your attorney's giving you advice about something, you could talk about that advice. But if you're talking about hiring or firing a management company, that is never executive session. That's always has to be an open. It doesn't fall into one of the categories. That's one I see all the time. I've been in many executive meetings where they start talking about that, or they start talking about just general landscaping issues. And that's not the time or place to do that. The 4th one on the list is the personal information about homeowners. That's why we talk about collection issues in executive. We don't want to air that dirty laundry. I had a client one time ask if they could post kind of on a red paper the delinquency list on the bulletin board of all the owners who are delinquent in the community. Please don't do that. And then the last one would be violation notices. You talk about violation notices in executive. Now, if your owner appeals that violation and demands that it be heard in an open meeting, you have to put it into open. You can't do it in executive. Okay, so that's just part of the open meeting. That's where I see a lot of the violations. The other one would be emergency meetings. Okay. In the past, it used to be very vague as to what was an emergency and what wasn't. And associations were abusing that all over the place. Say, oh, it's an emergency. We don't have to notice it. We're just going to hold a meeting. 4 years ago, maybe 5 years ago, they changed that statute to say now that if it's something that can wait for 48 hours, then it's not an emergency. So, and again, there's a little bit of wiggle room there. But if it's something that can wait 48 hours, just wait, because all you have to do is give notice that a board meeting is going to take place in 48 hours. Just hold a board meeting. You don't have to wait till the 3rd Wednesday of March to hold your board meeting, or that next Wednesday, whatever it is. Just hold a special board meeting. But if it can't wait for 48 hours, then you can have that emergency. That's another common one I see. Videotaping the meetings, sometimes that becomes an issue, which owners are allowed to do. You can't tell an owner no, unless the association has their own video camera set up, and that's the official recording of the meeting. Most communities don't do that. Just if you want to record, and that's fine. Question over here, Bruce. Oh, okay.
Is the management company or anyone on the board responsible to say, hey, we can't discuss this in executive session?
That's a good question. And you hire this management company, you hope they give you the guidance. I like most of the management companies. I don't want to talk bad about them, but there are some out there that you wonder, what are we paying you for, right? I mean, now they're not attorneys, right? They're not there to give you advice, but you would hope that they would help guide you through that and tell you when maybe you need to cut it off. You're not going to pay for an attorney to be at every meeting. You go broke, right? I mean, they're too expensive. So I don't know. I mean, they should tell you, I would say, but but also I would say, though, to counter that I think board members have an obligation as your duty to inform yourself of the rules and to know what the law says. Come to these types of things. I mean, there's so much education in this state offered by attorneys and cities. I mean, if you're going to sign up to be on the board, you need to be all in. You need to know what that means. And so I would say there's a little bit of blame on the board as well. In the back.
We have a virtual question. Can violations of homeowners be in open meeting minutes? Homeowner did not want everyone to know.
So that's a good question. So if you go back to the statute, it's not up there, but if you look at that statute, the way it says is that you may go into executive session for the following 5. It doesn't say you have to. So the answer to that question is yes, you could discuss it in an open meeting and you could put it in the minutes. Now, there's kind of the practical side of things of, well, one, the attorney-client privilege, like I said before, if you talk about that in an open meeting, it's no longer attorney-client privilege. It's gone. It's just an opinion that everyone gets to share. Information about a homeowner's delinquency. Okay, there's still the argument that people like to throw around, the right to privacy kind of thing. Then that's legitimate. You just don't want that headache. Just don't air that to the community. Maybe the same could be said about violations. But again, remember, if you can talk about an executive, you have to do it in open if they request it. So I wouldn't be as concerned about talking about violations in an open meeting. If that's, yeah, Bruce.
Another one, can board talk other than at meetings?
Oh, that's one I forgot to talk about. So in the open meeting laws, let's talk about quorum of the board. Everyone knows what a quorum is, right? Almost every time it's a majority of the board. The open meeting laws, and then this is probably the more common of the violations, I should have said. In the event that a quorum of the board is meeting, or not even meeting, together, talking about association business, okay? You have a quorum now. You're talking about association business. Let's say you go to the mailbox, you run in, let's say 3 of you are on the board. You're at the mailbox, you start talking about the landscaping, okay? You didn't notice your little get together at the mailbox. You didn't tell anyone you were going to do it. Owners weren't there to participate in your discussion. I mean, I say it and you just kind of laugh about it a little bit, but the letter of the law says what it says. If you have a quorum of the board discussing association business, you have to have provided notice of that meeting. So board members can get together. They can talk to each other. Just be careful what you're talking about. Don't talk about association business if there's a quorum of you together. The other thing that comes up are emails. Okay, that's the way we communicate now, right? Text message or email. Is it a violation if someone sends out an email to the group and one of you hits reply all to the other 4 board members? And so now all 5 of you are having a communication over email about an association matter. I think it is. And I caution my clients on email communications. If your manager maybe sends you an email to the group, don't hit reply all, just reply to her. Just try to avoid those big group emails where you're talking about association business, because I think you could get dinged for that as a board meeting without noticing your email conversation. I haven't seen a case yet where that's gone to where the court has said that, yes, that is a violation. But that's the caution that I give with emails. Now it's going to happen. It happens every day. You have emails, you're setting your agenda and things. And so most of the time, no one's ever going to take the time to challenge it, but you got to be careful. You got to know what the law says.
I had two questions about that. Our 5 directors have we have private email addresses that we've created for us.
That's smart.
We have our enterprising owner who knows all of these, how I'm not sure, but she will email all of the directors at once, asking for things to be done or doing whatever.
Yeah.
I have said, you are trying to get us to have a meeting that's not an emergency.
Yeah.
She says, I don't understand the open meeting law. And she trots out Mark Brnovich, who apparently wrote some kind of opinion. And then I trot out Grant Woods, who wrote an opinion back in 1997.
Yeah.
The way I read whatever Mark Brnovich said was kind of that he agrees with Grant Woods. But she's telling me I'm wrong. And does she just need some education, or do I?
I don't know. I don't think you do. Well, there's many ways you could respond to that, but it's, thank you for your input. We'll talk about it at the next meeting. And that's, what else can you do? You can't make a decision for her right then. You can't tell her we're going to do certain things right then. I would just try to kick it to the next meeting and say, thanks, thank you for your advice, your input, and we'll talk about it.
Well, all right, let me throw this in then, because one of her friends is one of the directors.
Okay.
So she will respond to everybody and say, oh, I think this is an important topic. I said, don't ever do that again. You just created a meeting.
Yeah.
Am I wrong?
No.
Okay.
No, you're not, but I mean, it's probably gonna happen again. I mean, you can only do so much to try to curb that, but you're not wrong in what you said. At least doesn't sound like it.
I just want.
It's, and let me just say, and then we'll get to your question. It's just this law, it's hard to navigate, you know, because of the convenience of the way we communicate and the way we do things. And so all I can say is this is what the law says, kind of govern yourselves accordingly, knowing that most people don't challenge that kind of stuff. You're probably never going to find a lawsuit against that, but you just got to be careful and just know what the law says when it comes to meetings. So we have a question
Hey,
here.
Quinn, before we go to, we'll take this question, but I see we have 2 virtual questions and we're at number 5. Can we do the rest of the presentation and do questions at the end?
Sure.
Okay, here's this. He is.
I'm gonna make this real quick.
Okay.
I understand quorum, but quorum should be in effect when you have 5, correct? So you have a quorum of 3. I'm just going to give you an instant. Our little quorum creates a switching of the board's positions, unbeknownst to the other 2. Calls a meeting, stands up, agenda 1 is to alter board positions, unbeknownst to the other 2 members on the board. Is that legal?
So the 3 of them held their own little meeting.
Yeah, they made their own switch of appointments, knocked the other 2 out of their chair. They were president and vice president. Those 2 people knew nothing about this transaction and said openly, we know nothing about the switch. And they said, we can do it. We're a quorum.
Yeah, I don't know that I can answer definitively without seeing what your documents say. That's why I put the documents up there, that in addition to the statute, you need to know what your documents say about notice and those types of things, whether that could be done. It doesn't sound right, but I don't know.
About the other 2, as long as the attorney is involved. We had the same situation in ours.
Well, I would also.
3 of us wanted to have a problem with the 2, so you call the attorney in and the attorney in the conversation with the 3 is allowed.
Okay.
As long as the attorney is involved, then it's allowed.
So the question though is really.
The attorney has to be involved in a quorum discussion.
Well, the issue really is what does constitute that quorum, and if you have 5 people on the board, if 3 of this, I get this question a lot actually, where if there's 5 on the board, but only 3 of them show up at the meeting. Actually, let's say, yeah, well, no, that would make sense. I'm trying to think of the example where, think of how that goes, where it's not enough show up. Anyway, I can't think of the example, but it does come down, if 3 of them are there, my question would be, was proper notice given? You know, was there proper notice of the meeting? If there was, and 3 of them were there, that's a quorum, and they can conduct board business if there's a quorum. So it kind of depends on what's happening. But and just in the interest of time, let me get through some of these. And just so you know, Bruce, some of the ones in the middle were more heavy on some of these others will go quicker. So we'll get through this. Improper board actions. Okay, this is that fiduciary duty I mentioned before. This is where the board acts outside of its authority. It doesn't have the authority to do whatever they're doing. And this is where you need to be very familiar with your bylaws and your articles of incorporation. Okay, mainly your bylaws. It will talk about authority. Statutes deal with this as well on what you can and can't do. So this is a much more broad topic. But the takeaway from this topic is that fiduciary duty. All of you, any of you who are on the board, when you sign up for that, you have now taken on the role as a fiduciary to the association. Okay, you're not a fiduciary to a homeowner. You're a fiduciary to the corporate entity that is the association. That's where your duty lies, is to the association. You have to do what's in the best interest of the association. Okay, now that is very easy for me to sit up here and tell you that's what you have to do. Putting it into practice is much harder. That's why that goes back to a lot of this stuff kind of comes together, where if you're talking to an attorney, you have that advice from counsel. Your manager maybe is a competent manager and is helping you out. You have that where you've relied on that. Now you're doing what you think is in the best interest of your community. You have the advice to back it up. You've probably met your fiduciary duty. But a common claim that we see when associations get sued is they'll name the board members and they'll say that they breached their fiduciary duty because they didn't maintain the property right. They, maybe they amended their documents without the right authority. They didn't follow what their governing documents say. That's a breach of authority. That's a breach of your duty. That's a valid claim. And you may have to defend against that. So the key to this one is to make sure that you know what you have the right to do and what you're not allowed to do. And if your documents are silent on something, you probably don't have the right to do it, right? One common one that comes up is taking out a loan for your community. Many times the documents are completely silent on the authority to take out a loan and encumber all the assessments of the community as collateral, for paying back this big loan. So that's something you have to work through with your attorney, whether you can do that. That's a common one, just real quick. That's a common one that I see. Not holding proper meetings and then conducting business in improperly held meetings. That could be an issue. Failing to properly maintain which we'll talk about in a minute, your common areas, that could be a breach of fiduciary duty. So a lot of times too, attorneys just like to throw that claim out there. Just you breach your fiduciary duty, but then when it comes down to the facts actually come out, they don't really have much to support it. Conflicts of interest. Someone mentioned the conflicts of interest. There is a statute on conflicts of interest. And as I'm talking, I'm going to look through this. Conflicts of interest, it's a very important topic for members of the board because, and I'll explain what a conflict of interest is here. It's essentially if any member of the board stands to benefit financially from a decision. Okay, now it's not just a member of the board. It could be the member's spouse. It could be the member's in-laws. It could be children, relatives. We had a community down in Maricopa a couple years. Well, this is prior to COVID, and the board president. I wasn't at the meeting because I don't go to many meetings, but they wanted to hire a new landscape company, and they went out to bid, and the board president came back with this bid that was way lower than the other ones. And they're like, "Oh, this looks great. They're going to do all the work for much less money." So they signed a contract with this company. Come to find out, like a month later, that the landscape company belongs to his father-in-law. And he didn't bother to disclose that when he was going through the process. And the reason that is such a big deal, why can't I find this on here? Is that any contract that you enter into that is where there's a conflict of interest, I'll find it and I'll get it to you at the end of the class. And if there's a conflict of interest, you have an obligation to disclose that conflict. That's all you have to do. In an open meeting, you have to say, you know what? This company belongs to my father-in-law. That's a conflict of interest. I'm not going to benefit myself personally, but my father-in-law will. There's the conflict. The law actually allows the board member to vote on the issue at that point. They don't have to recuse themselves under the law. They should, but they don't have to. As long as you've disclosed that conflict, your hands are clean. If you don't disclose that conflict and it goes through, you will now have a void contract. Okay, the contract's void as if it never happened. That creates a big problem, right? You have on the one hand a vendor who thinks that you signed a contract. Now it's void. Well, they want to get paid. It wasn't their fault that it's void. They're going to come after the association for payment on that contract. You have the owners who said you had no right to enter into that contract. You didn't disclose the conflict. They may have a claim against the board, and particularly the board member who didn't disclose. So if my takeaway there is if there's any chance that there might be a conflict, just disclose it. That's all you have to do. Then you can even vote on it. Just throw it out there just to make sure you're covered. So I'll get the statute when I'm done. It's in there, but and I'm just going to skip that Zlobotny case. It's kind of a boring case anyway, but I want to make sure we get through what we have here and leave some time for questions. Okay, this is one coming back to one of the, I think it maybe was your question from before. Yes, and many people do. This is number 3 on the list at the Department of Real Estate. This is the 3rd most common claim that they see. The one before was actually the 4th most common claim. I've had multiple. I have one lawsuit in my office right now we're defending on this issue. Association records. Every member of the association is entitled to see most association records, right? There are some records you can withhold from a homeowner. And it's very similar to that executive session list. The attorney-client privilege, pending litigation, information about homeowners or employees, violation notices. I think there might be one other I'm forgetting. But essentially what the law says is that if a homeowner makes a request for records, job performance, meeting minutes, executive meeting minutes, that was the one I was forgetting. They don't get to see those. But if someone makes a records request, the association has 10 business days to provide either a copy of that request or to set up a meeting where they can come inspect the records. And that's usually at your management company office is where that takes place. You can charge 15 cents a page if you're making copies. What happens, why this turns into a lawsuit is because homeowner associations either don't timely turn over the records or they don't give you everything. They withhold records that they had no right to withhold. And this is, I mean, I get letters from attorneys all the time on this issue that you've got to give us the records. Even on unrelated claims, the attorneys who represent homeowners out there, they love to throw that request in there at the end of the letter. It's like we're disputing the maintenance of this particular item. By the way, give us all your records for the last 3 years, and we want to inspect it because they're going on a fishing expedition. They're hoping they can find something that's there or not there. So when you get that request, someone on the board or the manager has to do that calendar reminder. We have 10 business days, weekends, holidays excluded. Okay, it's 10 business days from the date you get it. You got to act. You got to set up that meeting. You got to give them the records. You might be able to extend that if you can get them to agree that you need more time. But you have to act on this. Now, the statute is silent on the number of requests they can make. And this is the case I have. This lady has made dozens of requests over the last couple of years. And it's cost the association so much money because the management company charges extra for that work. And it's created a bit of a mess. But as long as they're not, repeat documents. So you can tell someone no if it's a repeat document. But she gets creative and kind of figures out other stuff to ask for. And she just asks for it. So what is a record? That question comes up all the time. I would say really anything that has to do with association business is probably going to be a record. Does that include your emails? Maybe. We have withheld emails before. If it goes to litigation, you got to believe your emails are coming into evidence. And that's why I love your example where if you get on the board, I really recommend that you create a new email address just for association business. Don't give them your Gmail account as an association email because when we get served with a lawsuit, they're going to ask for the last 3 years of email communications and you're going to have to give me all your Gmail emails and we're going to have to sort through which ones are association, which ones aren't. And I mean, I don't want people snooping through emails and I don't think anyone does. So set up a separate email account for if you're on the board. And that way it makes it very easy. If this was my time on the board, here's all my emails. Makes it easy. So that statute, the 11-11-601 is from the Nonprofit Act. That gives you a list of records that the association should maintain and for how long. Okay, there's some that you should maintain indefinitely, like meeting minutes, governing documents that you should never throw those away. But it talks about records that you should maintain and retain. So any questions on so I think it was your question, ma'am. The question of we're asking, or they're not giving us a budget. Is that what it was? We haven't seen a budget. Ask for it. Make a records request, and they've got it. There's okay. Well,
next year comes up and they still don't.
Okay. Well, that was going to be one of my answers is that maybe you go through the records request process and you can ask for that copy. Okay. Well, it may require a longer conversation then to kind of figure that one out. Was there a question, Bruce? Okay.
So the first one from Carolyn is what to do if board never responds to homeowners' questions nor the management?
Never responds to questions.
Yep.
My hamster wheel is turning, wondering if they even have an obligation to respond to a question. I mean, there's nothing in the statute that says you have to respond to a question. If they're requesting records, you got to respond to it. If there's some other legal issue, maybe you got to respond to it. But I can think of examples where owners are such a thorn in the board side that they just are going to ignore them, and that might be okay depending on the situation. So I would say go to a board meeting, and try to ask your question.
That's good. Another question. I understand that a group email can technically violate the open meeting rule, but when no decisions have been made that affects homeowners, what could a homeowner sue about?
And that's a great example of why you probably aren't going to ever get sued over this, is that the statute refers to association business. It doesn't mean that it has to be conducting business or just talking about what we might do at the meeting. I think both could trigger the statute, but I think it's a good point that if you haven't done anything to bind the association or to incur financial responsibility, there probably isn't any damage other than a slap on the wrist to say, stop doing it, which I mean, the Department of Real Estate, I've seen lots of those slaps before, just cut it out. So you need to abide by the open meeting laws, pay this lady $500 for filing the claim and go on your merry way. I mean, that's usually what happens. So there might not be some sort of damage that you're suing for, but you can get what's called declaratory relief or injunctive relief, where that's a court order saying you must abide by the statute. So, and there could be attorney's fees that go with that if they hire an attorney. Is there a question here?
Is there any scenario where a community manager should be initiating a motion? Community manager is not a director. She's not a member of the community.
I think technically speaking, they probably shouldn't be. But I have seen many community managers assist the board because they don't know the proper process, you know, Robert's Rules of Order or the proper way to conduct a meeting. And I've seen managers, well, actually, as I was saying that, the manager will say, okay, this is what you do. Now, someone needs to make a motion and then someone will make it. If the manager is actually making the motion, that's probably not right.
No, she started out and said, can I get a motion to do the following?
I think that's okay. I do think because she's not making the motion, that the board member's coming up and actually making the motion.
Well, she kept pounding away on it and pounding away on it until one of the board members did make a motion.
Yeah.
But further, she waited until we went into executive session, and this topic does not fit in the five
That's a
categories.
whole nother issue. So yeah, that could be a problem there. But a manager assisting a board and making motions and doing it the right way, I think is okay. I mean, I think that's one of the reasons you have a manager, is to make sure you're doing it the proper way. So, but it is a fine line, right? It's that is concerning that they would do it that way, but. Okay. Two more here. So just be aware that statute exists. If you get the records request, don't ignore it. Okay. Okay, maintenance issues. This is number 2 on the list from the state. I would agree with this, that it's probably the second most common one. This usually comes in the form of association, you failed to maintain X, and now my unit is leaking because you didn't maintain the roof, or my garage is leaking because you didn't maintain the 2nd-story balcony, or I fell in a hole because you dug a hole in the common area and didn't fill it in, you know, something along those lines. But it's more really about the maintenance and who has that duty to maintain. So whenever, and I'm defending a couple of those right now as well, one I'll talk about. It really comes down to, you know, who has that duty to maintain in your community. And that's actually a legal opinion that I give quite frequently. I've put up there the maintenance matrix, especially for condominiums, because sometimes documents in condominiums, first, they're not going to identify every specific element or part of the condominium and tell you who's supposed to be responsible to maintain it. Right? It's not going to list out everything from gutters to windows to shutters to, sometimes it won't even say windows. And then you got to try to figure out, well, who maintains the windows. Statute can kind of help you with that. But so if you're unclear about what you maintain as a community, then we need to address that, or you need to address that with your council. You need to find out, what is it that we have to maintain? Where does our duty lie when it comes to maintenance? Newer documents provide a lot more guidance on this than 1960, 1970 documents. And it's interesting, the decades, how all the documents seem to be the same. Like if you tell me you're from the 70s, not you, but your community, I could probably tell you right now where the different provisions are in the document, because developers are lazy. They take one document for one community, they just recycle it, put it in the next one, and it just makes its way through the state. And it's the same happens today. You see the same documents, you know, over and over. But it does kind of go with the decade, it seems like. So you need to know what you maintain as a community, and what do the owners have to maintain? You know, what are owners responsible to maintain? That goes to insurance questions as well that we talked about before. So maintenance is a very common one, and can lead to a lot of liability if you don't properly maintain. Now, how many in here have conducted a reserve study in their community that you know of? How long has it been? Just throw out some numbers. Okay, 2 or 3 years. Okay, anyone older than 5 years from last time they did a reserve study? Some communities I've seen that don't ever do them. Does everyone know what a reserve study is? Let me just ask that. So reserve studies are very important because it will go through and give you the kind of the life of your assets, essentially. You know, how much longer are these roofs going to last before you have to repair them? That goes to the budgeting issues and the assessments and how do we plan for this? But it also is important, you have to know what you maintain and what you are obligated as an association to deal with. And as board members, you have to know this because you're making the decisions on maintenance. And if you fail to do something because you weren't aware of it, then that's the breach of fiduciary duty claims. That's the property damage claims that you're going to have to defend. And like I said, sometimes it's not very clear what it is that you have to maintain. Bruce, I think we have a question here.
For the purposes of fiduciary duty, relying on experts, is a reserve analyst
Yes.
considered an expert?
Yes, I would think so. Yes. One more over here.
If the reserve study says you have to repaint, do we actually have to do it even though the world changed?
So that's a good question too. I mean, if the study's just giving you kind of guidance of what you should do, you still have to figure out, I mean, because most of the time you're not going to be able to afford everything they tell you to do. Most of the time communities come in 30% funded of what they need. And so now you got to spend the next 10 years trying to raise money to then pay for the streets or pay for the roofs or paint. And that's a decision you have to prioritize. What's the most important thing that we need to do? And let's figure out how we get the money for that and let's do it. And I think as long as you're doing that, I mean, if you don't paint, I don't think there's liability because the reserve study said paint tomorrow and you don't paint for 2 years. There's a lot of factors that go into that as to why you didn't do it tomorrow. And I think that's all fair in a defense against any sort of claim. We didn't have the money. We had to raise money. So that all factors in. There's a question in the back. One more.
This is a follow-up question. It was actually the board that was not responding to a hearing request.
Oh, they're appealing their violation, asking for a hearing. Okay. What was the question? What can they do?
Yeah, what can they do if the board isn't responding to that hearing request?
Well, they can keep trying. And they can always hire an attorney. They can go to the Department of Real Estate and make a claim. That's what a lot of homeowners do, just to try to enforce their rights. So that's what I would recommend. As far as maintenance, I wanted to tell you one thing that sometimes it's hard to know. I have a case that it's not fully resolved yet, but a homeowner came to the board and said that his unit was sinking. They were 2-story condos. The first, he owned a ground unit in the corner, and the back bedrooms, like they came in and had a test done where the guy was literally rolling a ball and he could start it in the front and it would roll all the way back to his back bedroom. And it was probably 5 inches or maybe more from front to back. And it was a foundation issue. They hadn't installed proper drainage on the side. Water was accumulating at the base over time. And this was years, and it just started to sink. And you look at the documents and the association has an obligation to maintain foundations as a common element. That's not something the owner has to maintain. And the owner sued us and said, you have to fix my foundation. Well, you're right. I mean, there's no real defense to that. So we're working, had to work through insurance and get the money, and it's not cheap to go underneath a foundation and prop up a building. So that's one thing where I would say most of my clients don't go around inspecting their foundations, right? That's just something that might happen. But so there are a lot of parts of your community that you may not even think to maintain. And that's why it's so important that you have a list of, this is everything we have a responsibility for. And if they had told me years prior, foundation would have been on that list. And maybe we need to get that inspected just to see how the foundations are doing. So anyway, just be aware of that. So we got 15 minutes here, 14 minutes. So the number one issue, and I fully agree with this. This is from the state that the most claims were filed on this were architectural and design review issues. So what happens here is a homeowner comes to the board with an architectural request, say, I want to build whatever. I want to paint my house. And the board now has to make that discretionary decision of yes or no. We're going to allow you to do this, or we're going to tell you, have a nice day, try again. And that's where the lawsuit comes in, is that as homeowners are told no, they don't agree with the decision, and they sue the association saying, you didn't have the right to tell me no. And there's all types of arguments that come with this. Tierra Ranchos is a Court of Appeals case from 2007, I think, that talks about the association's duties when it comes to these discretionary powers. This ability to say yes or no, where your documents aren't going to lay this all out for you. The documents are going to say the architectural committee gets to decide. Well, actually what it says is owners are not allowed to make improvements without the approval of the architectural committee. That's what it says. And so the architectural committee now is tasked with that authority to say yes or no. That's that discretionary authority. When they exercise that authority, either the board or the ACC, you have to treat members fairly and you have to treat them reasonably. Well, what does that mean? What does reasonable mean? And I don't have a good answer for that, other than sometimes it's the person wearing the black robe behind the bench that tells me what's reasonable, because I don't have a great answer. But you look at kind of the pattern of things. What have you approved in the past? What exists in the community right now? Do we have a basis to tell this person no? Is it different from maybe something we approved before? That's where it comes down to treating people reasonably and fairly. You also should have a process in place that every person follows when it comes time to make a request. This wasn't on my list, but we've talked about it. One of the questions, the violation process, enforcing. You have that enforcement policy in place that if you don't ask for permission, here's what's going to happen, or here's what could happen. So when it comes to that design, it goes back to understanding what your documents say. What authority do we have as a board or as an architectural committee when it comes to approving these matters? And then you have to understand too, what does the rest of the document say about what's permitted in this community? Are they allowed to have a basketball hoop in the driveway, or does it have to be in the backyard? Can RVs be parked on the side? Can the guy build an extension to the fence? Those types of things. What are the setback requirements? There's a lot of moving pieces that you have to understand when it comes to this architectural stuff. And I have my two. I'll get your question in a minute. The two cases I have that I've just now settled just two of them, but it was a little bit different where the board had told both of these owners no on a request. One wanted to put a gate in the front entryway, and the other person wanted to make drastic changes to his front yard, the landscaping. But in both cases, the association told them no, and they had good reasons for both. They had established design requirements for the gate of what it needs to look like, because every other gate in the community is designed the same way. The other case, the guy wanted to put in just these outrageous light fixtures and rock that clashed with everything else, and they said no. In both of those cases, the owners sued the association for telling them no and said, you should have said yes. And so then we were defending against these claims, defending our decision and saying no. And we've prevailed on both of them, but you do get that common claim of, well, you're treating me differently, right? You let this other owner do this, or really, what's the harm in letting us put a gate that's a little bit different than the rest of the gates? So you kind of have to work your way through that. And these are tough cases because the board is, the attorney might tell you one thing, but at the end of the day, most of these decisions are just made by the board on their own. And you hope the manager's there to help them. But that's why I think this is the most common one, is because it's very easy to kind of operate on principle, right? And say, well, we just don't want it, when the documents may not allow you to say no. So you just have to be careful with architectural stuff. Another question here.
So would you recommend an architectural committee? And I guess what's the power of these committees, and are they supposed to work?
Now most communities that have architectural committees, their CCNRs call for it. They say that, either you have to have a committee, or the board has the authority to appoint a committee. Those documents will then talk about what is it that the committee does. Does the committee have the authority to create design guidelines, kind of establish that process? Or is that something the board has to do? Some documents are silent on that, so you don't have to have an architectural committee. I mean, I guess the really only benefit I could think of is it's one less thing the board has to do. I mean, as board members, it's a thankless job. You don't get paid enough. Hopefully you're not getting paid anything, but it's one other obligation you might have the right to convey to someone else as a committee. But again, it's what can they do? That has to be dictated by your documents and what the authority is. Going back to that authority slide. Yes, sir.
Coming.
Can an architectural committee have 3 board members on it and a 5-member board?
The answer to that is yes. Well, actually, you're thinking of quorum. Well, I mean, I think I would stick by my answer. I think they could, but you're going to have to. That can make things a little tricky. Keep in mind, if you're in a planned community, there is a statute on this that says, for those of you in single-family homes, your architectural committee has to have a member of the board on it, and that board member has to chair the committee. Condos don't have that same, but a lot of condos don't have architectural committees for various reasons. But to have three, now you could argue too that the board, they're acting as members of the committee and not members of the board. But that's kind of that fine line that I don't know that you even want to mess with that and deal with that issue. But I think you could. All right. That's all I want to say on that one. I had two honorable mentions. Board member removals and condo terminations. Board member, anyone had to deal with a board member removal in your community? You tried? Right? I mean, that's usually what happens. We try and we don't succeed. This doesn't usually result in litigation, but it's so litigious and it's so acrimonious that I put it in the same sort of group. That board removals are they can tear apart a community. I mean, I live next to one in Gilbert area that has gone through, I don't know how many board removal meetings in the last 5 years. Seems like every cycle they're doing another one. So there's a whole process on that, and I can talk to you later about it if you're curious about how it works, but it's in the statutes. Condo terminations, this has been in the news lately. There was a change to the statute on condo terminations just this past legislative session. There's a case that's actually going to this, well, it's being appealed to the Supreme Court right now on condo terminations. So we'll see if the Supreme Court takes another case for associations. But if any of you are in condos, if you're curious, the statute allows you to terminate your status as a condominium. And usually when this happens is a developer will come in and buy up a whole bunch of the units and wants to convert it to apartments. Right now, the way the law reads is if 80% of the owners sign a condo termination agreement, you can terminate the condo, force the other 20% to sell their unit at an established price that an appraiser gives for that unit. That's where the litigation comes in, is we don't agree with the price. There's an arbitration set up for that. But that's being litigated right now, whether or not it's even allowed. A constitutional statute is what's being challenged right now. So, and with that, I think that's on my list.